A severance agreement comes about when there's a separation of employment and the employer wants to give to the employee benefits to which they otherwise would not be entitled in exchange for the employee releasing any and all claims that they may have against the employer. The common terms in a severance agreement would include things like the amount of the payment, the timing of the payments, if it's going to be in one lump sum or if it's going to be over months of time. Then there's some general categories, what's almost always within any severance agreement. For example, a non-disparagement clause. The company and the employee don't want to say bad things about each other. There's often a confidentiality clause by which the employee agrees to keep the terms of the agreement confidential, only sharing with their attorney and their spouse and their financial advisor. And sometimes, if the employee was at a certain level, there's a cooperation clause which says that the ex-employee will come back and help the company if there's a dispute with an employee or a contract or something. A severance agreement normally doesn't alter some existing requirements. For example, an employee is always required to keep trade secrets secret. If there's a non-compete provision, a non-solicitation provision, then it probably won't change that. Sometimes a severance agreement tries to add in a non-compete agreement or a non-solicitation agreement, and that has to be looked at carefully to see if it's legal, if it's appropriate. There's usually a mediation clause if there's an argument over the contract. If there's a breach of some kind, usually there's a binding arbitration clause. One of the claims that gets released, if it's an age claim, if the employee is 40 years or older, then that by law, employee has 21 days to consider the offer of severance. And even if they sign it, they have 7 days to revoke it. And finally, there's usually which law will govern. Now, you might assume because you're in Colorado that it would be Colorado law. That's not always the case. If the company's headquartered in another state, let's say New York, they may say, oh no, we want New York law to apply. So it's a really good idea, and they even usually tell the employee this: go ahead and consult with an attorney. We meet with lots of folks here at Miller & Steyert who have severance agreements. We work them through the terms and how to help them understand what's going on. So don't hesitate to give us a call.